My name is Karen Lee Pollock, and I'm often asked by clients, how do I bring an employee to live and work in the United States? How do I get them a green card? Well, the first question you need to ask is the employee currently living in the United States, or are they located overseas? The second question is to determine the employee's educations and qualifications. Those questions will affect the procedure that you will follow to obtain a green card for your employee. There are three categories of employment-based visas that are used to obtain a green card. The first one is called an EB-1, or Employment-Based 1 category. This is for aliens of extraordinary ability in the field of science, business, or the arts. The second is the EB-1 for managers or executives who have worked for a foreign company for at least 1 year and are being transferred to live and work in the United States for an affiliate, subsidiary, or branch. The final EB-3 phase is for outstanding professors and researchers who are on tenure track at a U.S. university. The second type of green card is Employment-Based 2, or EB-2, and this is for people with advanced degrees from a U.S. university, or if they have an undergraduate degree and 5 years of experience, or there is a national interest waiver for those of exceptional ability, which is a slightly lower standard than the EB-1, alien extraordinary ability. Finally, there's the EB-3 visa, which is for professionals or skilled workers. What category you fall into as an employee is very important, because in certain categories there is no wait time for a visa, and in other categories the wait time is very long. So, for example, if you qualify in the EB-1 employment-based category as a manager or executive coming to live and work in the United States, there is no wait time, and the process will probably take about, in total, 18 months. There are visas immediately available for you. However, if you are in the EB-3 category and you are a professional or skilled worker who does not have a degree or has a degree and less than 5 years of experience, there is a very long wait time. Generally, the wait time right now, the USCIS is working on cases filed in 2006. So there is at least a 6-year wait. For citizens or nationals of India and Mexico, the wait is even longer. So it's very important when you meet with an immigration attorney to really talk about your education and qualifications to determine what is the best visa for you to obtain. Once you have decided on that, you can start the process. If you qualify in the EB-1 category, you do not need to do a labor certification process or application, which is commonly referred to as PERM. That also can speed up the visa. So if you do qualify in EB-1, which is a tough standard, that is always the way to go. If you do not qualify in the EB-1 standard and you qualify as an employment-based 2 or employment-based 3, before you can file any application with the USCIS, or United States Citizenship and Immigration Service, you have to go through a lengthy process called PERM and file a labor certification application. This is filed with the Department of Labor and shows that there are no U.S. workers available to take your job. Before you can file that application, you will need to advertise in a local newspaper and do various other recruitment proceedings, as well as advertise with your state workforce agency for the job. The employer will have to interview any candidates who seem to qualify for the job on the face of their resume, and can only not hire them if there is a lawful reason not to hire them. They cannot discriminate based on unlawful grounds. This is a lot of work for the employer, so it's really important to determine the best visa category from the start. The time it takes to get an adjudicated approved labor certification varies depending on whether there's an audit or the Department of Labor requires additional information. Typically, if everything goes smoothly, you should get approval within 90 days. At that time, you can file the petition for alien worker with the immigration authorities. That is called a Form I-140. And that is to certify the job position and to give information about the employee and the employer. Once the I-140 is approved, you can file the second phase, which is either the adjustment of status, application for a green card, if the employee is already in the United States, or you can consular process and file forms with the Kentucky Consular Center and the U.S. Consulate in the home country for the employee to obtain a green card abroad. It is a very complicated process sponsoring an employer for a green card, and it is very important that you make all the correct decisions up front so you have a fixed strategy going forward to make the process as smooth as possible. If you have questions about sponsoring an employee for a green card, please call me.